Long story short, he's under the time gun and the seller can't get their act together. So what does he do? Welcome back to Confident Real Estate. I'm your host, JC. On today's episode, we're going to do another Q&A of viewer questions, this time from Amir, who's asking about title defect and chain of title issues. If you don't know what those are, you probably should. They're extremely important. So let's get into it. So Amir finds himself in a very precarious position. He's currently in contract to buy a piece of property. The sellers of the property are an LLC. The property is held under this entity, but the members of the entity are different family trusts. Typically, this is set up when the original owner of the property was somebody who wanted to pass the property along to their heirs. So they set up individual trusts for their heirs to inherit the property from them. And those trusts are the members of this LLC entity that owns the property. So essentially, Amir finds himself in this position where now he is buying the property. So much time has gone by that the family members involved do not have the original trust documents and they do not have the original LLC documents. So now he's got a mortgage in place, rate lock's about to expire. The title insurance company refuses to close justifiably because they don't have the ability to insure title for him. A title insurance company comes in and gives you a fee insurance policy that says if somebody comes and subsequent to you buying the property makes a claim on title saying this is my property, the people who sold it to you didn't have a right to sell it to you, title insurance steps in and defends you in that litigation because they've insured the title. Here, title insurance is saying we can't give you that insurance because the people you're buying from have not produced the documents to prove legally that they own the property because we don't know that they are officially the beneficiaries under these trust documents that they cannot produce as members of the LLC that owns the property. Long story short, he's got a problem. So what are Amir's options at this point? At this point in time, he is already locked and loaded and ready to close. It's the seller who is not able to close. It doesn't appear that the seller is willfully defaulting. And what does that mean? A willful default is when the seller says, I know you're ready to close and we could close, but we're not going to close because we would rather get out of this contract, give you back your down payment deposit, and go forward with somebody who came along after we entered into contract with you to give us a higher offer. Doesn't seem to be the case here. It just seems to be the case that the seller can't get their documents together in order to properly close. So, the current situation, purchaser, Amir, his options are to look at his contract. Potentially, he can serve the seller with a time is of the essence notice. Based on whatever the state law is in his jurisdiction, the time is of the essence notice will say, you have 30 days from the date hereof to close. If you do not close 30 days from today's date from this letter, you have to give me back my down payment deposit. The contract is canceled, null and void, and neither party has any further rights or actions against the other. Right. But what does that do for Amir as far as getting back all the money he's expended for, again, title insurance, surveys, mortgage applications, etc.? The issue is he needs to look at what his contract says. Unfortunately, we know that he did not have legal representation when he entered into the contract negotiation, and that is why you always should have legal representation when you are negotiating the purchase or sale of a large asset like real estate. If he had a contract that had specific contingency clauses to enforce his rights, he might have other options. I know a lot of people, myself included, typically put in a clause that says, in the event seller is unable to close, you're going to have to give me back my down payment, and you're also going to have to reimburse me for certain expenses such as title insurance, surveys, my mortgage applications, my title report up to the point of searches, etc., that I came out of pocket for, any environmental and structural inspections I did. And if the seller fights you on it, you usually set a cap limit and say you'll owe me up to X amount. And that really shows you that the seller's really adamant that they're going to move forward and sell this property. They're not just fishing, which is not typically the case if somebody's willing to enter into contract to sell you the property. But it gives you that extra coverage so that if you find yourself in a situation like Amir now does, you have the ability to recoup some of those funds that you've expended beyond just getting back your down payment. Here, he doesn't have that option. So he's going to have to weigh the pros and cons and decide what he wants to do next. The other issue Amir could look into is whether or not the title company is just playing hardball and is unwilling to insure title because they're nervous about the situation with regard to the documents they've been provided for these trusts and the LLC from the seller. Maybe another title insurance company has a little more experience in this area and has dealt with this kind of transaction before and is willing to insure title. It all depends on who your underwriter is. I always recommend going with the national insurer, somebody like a Chicago, First American, Fidelity, Commonwealth, Stewart, etc. By the way, none of them have paid for advertising in this video. It is not a promotion or a plug. It's just something that I tend to find is useful, is to always go with someone who insures on a national coverage level, not a local insurer. They tend to give you the better flexibility in what they're willing to insure. That's it. Those are his options at this point. Without us knowing any further details of the situation, we're waiting for Amir to respond to give us more details, and maybe we'll follow up in a future video with more and possibly a resolution to how this all played out. We'll see what happens. But it's always good to be, again, represented by legal counsel when you're negotiating a contract, because you could have mortgage contingency clause with specifics. You could have seller default clauses with specifics that cover you so that you don't find yourself in this situation like Amir does. At the end of the day, there are people out there watching this video who are going to say, just close without clear title. I personally never would recommend that you close without clear title, because it is very hard to go forward and sell that property down the road if the same title insurance issue that you currently have comes up again when you go to sell, and you then have no ability to provide a cure for that title defect issue because you don't have title insurance, and the people you bought from, good luck chasing them down to clear the title for you at that point in the future. You also are going to have problems when you go to refinance the property. Typically, lenders will ask to have a new title report and search history done, and to have a lender's policy on the property. Now, here Amir has lender financing in the wings, so he absolutely must close with title insurance. The lender will never loan a mortgage on this property without a loan policy. If he was paying all cash, theoretically he could close without a title insurance policy for the fee title on the property. I, again, never would recommend that, because now if he then goes to refinance, do a cash out, pull some money out of the equity so that he could go buy another property or whatever he wants to do, any future lender would ask for a loan policy, and they would be curious as to why he doesn't have an owner's policy. He would have to explain the situation about how he bought what would be considered on cloudy title from the seller, and that is not a problem you want to endure. I hope you learned something from this. I know Amir did. Don't repeat the same mistakes. Make sure you get clear title. Make sure you get legal representation to represent you when you negotiate any contract for a major investment like real estate, and do your due diligence. Hopefully, again, you got something out of this so that you can go forward with a little more knowledge and a little more confidence into your next deal. Thank you again for watching. Don't forget to hit like if you like this content, and please hit subscribe, that little red button next to the like button. Again, thanks for watching Confident Real Estate. I'm JC. Be well.